You're good whenever.
Okay, thank you. Welcome, everyone. I'd like to call the Tuesday, November 28th, 2023 meeting of the Injured Employee Partial Permanent Disability Payment Working Group meeting to order. And I'll start by asking my co-chair if she has any remarks.
Thanks for everyone. Welcome today. Hope everyone had a good Thanksgiving and looking forward to our discussion.
All right, thank you. First up, if I could have a motion to approve the minutes of the November 14th meeting.
So moved.
Second.
Thank you. Any discussion on the minutes? Seeing none, all in favor, say aye. Opposed? Motion carries. All right, you all should have received an initial proposal which talked about modifications to 31308A 308B, which would be changes to numbers of weeks of compensation for certain body parts, and then also contain some changes, proposed changes to 31308A, and we'll go ahead and start off today by first having the proponent or proponents just offer their thought process and how they came to these ideas. And I don't know if Bud or Nate wants to handle that. Nate, you're on mute.
Am I better now?
Yeah.
You can hear my lovely voice. Wonderful. So the proposals that we sent, as I mentioned last time, were ones that Bud and I came up with, but we didn't do it in a vacuum. These are based on over 29 years of working with the current legislation that's currently in front of us. The changes that we're proposing reflect a lot of the thoughts of practitioners that handle workers' compensation, obviously from the claimant side, some from the respondent side, as well as some of the judges. Some are now retired and some are still present, that have expressed where they felt there were some shortfalls in the Workers' Compensation Act, which, if adopted, would make it a much more a fairer balance for the injured worker, but it would also give the judges more latitude and discretion in fashioning the remedy in the appropriate cases. By no means is this the be all and end all. This is what Bud and I came with in terms of starting the process and the and discussion with these things. We actually, there were a lot more, but we felt these were the seminal ones and the most important ones. And the thought is let's get the claimant's perspective out on the table in terms of where we see their deficiencies and how they can be addressed. And that's what was the genesis of this. Is okay, this is what the claimants see as something that issues that need to be addressed, and we hopefully we can. The question then becomes is, from the business community side, where do they see changes need to be made? Maybe they think none need to be made. Maybe they think some need to be made. Maybe they think some of these need to be made, but not as substantial or where we're at. And that's what we're here for. We're here to discuss these things. So the thought is let's get our position out on the table and let's have the conversation. Not a yelling, screaming match, not a slam down. It's either all or nothing from either side, but let's talk about it and see where we can come up with a consensus. And that's how I see it.
Okay. Bud, anything you'd like to add to that?
No, but I would just like to emphasize that the idea was to try to narrow down from the injured worker side of things what seemed to be the most pressing issues. So it wasn't meant to end the conversation. It was meant to start the conversation.
Okay. Now, what the initial genesis of legislation that I had proposed was solely concentrating on the 308A part of it. What's your thought process on capping it at 208 weeks or whatever the PPD weeks are, whichever is greater? And I know that comes out to 4 years, but I didn't know if there was some magic thought to that or where you were going with it.
Well, I can address that. The number of 208 weeks was when we were looking at the statute in its entirety and the balance on that. One thing that at least I saw is that when it comes to like a disfigurement or scar award, the commissioners have latitude up to 208 weeks. And so our thought was well, the legislature saw fit in the 93 amendments to cap it at 208 weeks. And they felt that that would be not an abuse of discretion in a disfigurement case. So the thought was well, if the legislature thinks 208 weeks is fine for the scars and disfigurements, which is essentially part of 31308B, why complicate matters and stretch it this way or that way? Just incorporate that same sort of a ceiling of discretion when it comes to the 308A part. So that's where we came up with the 208 weeks, or the PPD weeks. Now, in some cases, that may be greater. In some cases, it wouldn't go below 208 weeks, but the thought is there are cases where especially when you're dealing with someone with a back, or possibly a heart, or someone with a TBI, those benefits can well exceed 208 weeks. I would say that very few permanency ratings for the back, not so much for the heart or for a brain injury, it would exceed 208 weeks. I mean, you think about it with a 40% to the back, as it is now, you're going to be at whatever that would be, something like 169 weeks, I think it would be. So we think 208 weeks should be the maximum for the floor. But in those rare cases, when you're dealing with something that would be even more substantial, the commissioner should have that latitude to go higher. And I think commissioners, or I'm sorry, I keep saying commissioners, I think judges have that ability to understand that they're not just going to be, as been said before, give away all the candy in the store. So that was the rationale for increasing their discretion. It's more than what exists now, but it's less than what existed prior to 1993. So that's where we came up with that.
Okay. So as I read it, let's take someone who has a 10% rating of the back. So they're going to get 37.4 weeks for the permanency rating. Then right off the bat, they're entitled to up to another 37.4 weeks of 308A benefits. So this proposal would allow the commissioner, with conditions being met, to authorize additional benefits for 308A up to 208 weeks, minus whatever was already paid.
That's right. And let's take someone with that 10% of the back who was he was a roofer or she was a roofer and they can't return to the regular job because of that 10%, because they can't climb and of lifting restrictions. Let's say they're working a light duty job, so there would be a lost wage differential. We think that the commissioner's ability, the judge's ability, should go beyond 37.4 weeks in fashioning that remedy. Let's say they've gotten to a retraining program, and the retraining program, as we heard from 2 weeks ago, that they can award, I think it's usually 2 years, but she said in certain cases up to 3 years of benefits. So this would allow that to accommodate those situations. There's various ways to play with this, and I'm more than happy to talk about that. But we think this should be the starting point of discussion of increasing something beyond the limitations that we have now, tying it 100% to the specific number of weeks. So I think in your scenario, if someone did get into a retraining program, I think, and they would be awarded 308A benefits for why they're in the retraining, and if they got a job and it paid, and there was a wage differential, then after they've finished with the retraining, there'd be a residual that the judge could consider for additional 308A. It wouldn't be at the full base rate, but it would be based on a lost wage differential. And so it allows the various types of accommodations going something higher than the rating itself. We played with the ideas. There used to be this after the 93 amendments, when there were a lot of claims prior to 93 and then post 93, there was this sort of rule of thumb, and Bud can confirm it. And it was, I don't know who came up with it, but we called it the Frankel rule, where where it was suggested that for all claims prior to 93, you can award up to twice the number of weeks of the permanency for 308A. And that was sort of the yardstick that the judges used back then to in terms of discussion of 308A prior to 93. So that idea of having something greater than the permanency, but more than the permanency, but necessarily less than in an unlimited, seemed to be the approach we took. And when we saw that, as I said, judges had discretion of up to 208 weeks for disfigurement. I think it should be the same for the 308A.
What about immigration status on the 308A, Nate? I know, I don't think it's been decided, but I know there was a case pending on that issue. And I'll say it, in my practice, I have a number of injured workers who are undocumented and cannot get the 308A benefits, which, I think is patently unfair. Do you think we should address that in any proposed 308A changes, or should we let the court system play it out?
I think the CRB spoke. I believe they spoke about it in the Tuba decision. I may be wrong on it. I do know that it did address total disability. I see no reason why an undocumented worker shouldn't be entitled to, 308A benefits. And so in one respect, I think the CRB has spoken about it. Should that be addressed by the legislature? I think so. I think so. When they do it and how they do it, and maybe it's not within this forum, this working group to do that. But I think that's certainly something that needs to be discussed, because I think the undocumented worker, especially in light of what's occurring now, is going to be around for a while. And at some point, they may gain some sort of work status that's legitimized, whether it's through some sort of federal legislation or states just recognizing them on their own. That remains to be seen. But I do believe that that is a legislative policy decision that needs to be addressed, but perhaps is outside the scope of this group.
Yeah, I mean, with what I had originally put forward for 308A changes, I actually had included language in there that would make them allowable regardless of immigration status. So something clearly that we need to think about if we're going to propose any changes to the 308A statute. Now, one thing that I think that we're going to start to see more of are claims for disability because of PTSD and how we've allowed it for emergency services workers. Should we be thinking about making that a separate category, or should it remain as a brain rating, which is what it's been all along?
But do you want to take that one?
Yeah, well, that's a good question. One of the things we discussed was giving ratings to the various systems, you know, the neurological system, the cardiovascular system, because I think the more you mirror the AMA guidelines, probably the better off you are, since the doctors are all using the AMA guidelines to provide the ratings. And you always have a problem when the statute doesn't match the AMA guidelines, and nobody knows really what to do. But PTSD, the brain rating makes the most sense to me, but I'm certainly willing to entertain any other suggestions.
I mean, perhaps it's not anything that we need to get into at this point, because again, we're sort of in the infancy of how these ratings are going to be dealt with going forward. But, if anybody's got another thought on that, I certainly would be happy to hear it. Anything else that you or Nate wants to add on the proposal at this point?
Well, I can only imagine, though, on the business side, that the hesitancy with raising a cap is the thought process is that the judges are going to view it as kind of an automatic entitlement rather than a use of their discretion up to a certain number of weeks. And I don't know how we would address that other than perhaps providing more specific language in the statute as to who would qualify for these benefits.
Let's open it up, especially to my friends on the other side of the issue. What are your thoughts on what we have before us? And we'll take silence as acceptance.
I can speak for
Go ahead, Brooke.
a second. I just want to say that again, since the charge that we have is that we need to be able to have data to show that there's an issue that needs to be fixed, and what is the data to show that these ratings, these benefits are inadequate. And again, we mentioned that in the last meeting, and I think we need some support that there needs to be a change, and just making this proposal but without having any sort of support for it, is problematic to us. So I think we should establish first that there's even a problem that needs to be fixed with actual data.
My only pushback on that is I don't know what data was used in 1993 when they established the cap in the first place.
Zero.
Go ahead, Nate.
I would say zero. There's absolutely no legislative history whatsoever on the 1993 amendments. None whatsoever.
Well, I'm talking more specifically about like, how does Connecticut compare to surrounding states in terms of these benefits? Because, you know, the discussion at the last meeting was that we were going to try to come up with some sort of, you know, data to show how Connecticut compares in terms of, you know, what the PPD benefits are and just workers' comp benefits in general. And I think that first we should look at that and establish our first charge, which was in the, you know, the Public Act establishing this working group. I think the first charge was that we were going to look at that issue and see whether or not there's even a problem first. So I think we need to do that.
Brooke, were you able to ascertain what other states are doing in the neighboring ones? I think we mentioned New York, Rhode Island, and Massachusetts.
I was looking at some of them, but I was under the impression that your team was going to get that information.
Okay. We'll work on that because it's a fair point. Yeah, go ahead, Marie.
So after the last meeting, I did get an email from Justin Moulton, which with an attachment because he was watching. For those of you who don't know, Justin works for NCCI. So I'm going to try to email. I'm not very tech savvy. I'm going to try to maybe email that to everybody. If I have everybody come up in my address book here, I'll try to do that right now so that you'll at least have that.
Marie, if you take one of the meeting notices from Nate and just hit a reply all and attach that to it, that'll do it.
I don't know if I can do that because it's an email. I think I just need to forward the email.
Okay.
I'm not very tech savvy, Mike. But let me
All
see
right.
what
No, I mean, if you just forward it to one of us, then we can get it to everybody.
Okay, I'll do that. I'll forward it to you. And actually, I'll forward it to Nate because then he'll be able to do that. How's that?
Yeah.
Okay.
Yeah, don't leave it to me.
That works.
Okay. Anybody else have some preliminary comments on this?
Chairman, parenthetically, I thought I saw something maybe a few weeks ago that insurance premiums have dropped in Connecticut. And I think it was an announcement from the governor's office. And I would ask Brooke, is that true? And what's the trend on that in Connecticut?
I don't know the trend, but I did see that announcement.
Yeah, and I guess I would wonder if the rates have gone down because of the pandemic and not as many people working or going into offices, and thus the opportunity to injure yourself lessening. But you know, I would defer to the insurance experts on that.
I'm not sure, but I can tell you that in my what I would assume is that the proposal would be significant increases. You know, the changes would have and the impact of the changes would that the rates would increase significantly. So I would like to see data on that. That's what I would request.
Anyone else have any comments, questions, statements? Go ahead, Joe. You're on mute. There you go.
I think you muted me and I didn't know how to undo it. Yeah, I mean, I've got a lot to say here, as you might imagine, but you know, the thing with 31308A is, you know, our system has a certain level of tolerance for drastic change. And, you know, I think if I could describe, you know, this document in one word, it would be overreach. And really, more than anything else, the concern from my perspective, from my side of the table, is discretion, because discretion it can be a dangerous thing. And I don't mean that to mean ominous. I mean that to say, if you hand an administrative law judge discretion to award X number of benefits, then two things are going to happen. And that's just borne out by history back to 1993. One, they're going to award all of them. And more importantly, every settlement demand that we ever see is going to be premised upon the maximum entitlement. So you're increasing, you know, you're taking an 11.7 week 308A entitlement and upping it to 208, or 15.5 and upping it to 208, or even a 37.4 and upping it to 208. And, you know, the thing about 208 weeks that's interesting is that all the way back to the 1950s, when 31349 was promulgated, transfer of liability to the Second Injury Fund, while we don't know a lot about what the 1993 legislature thought in terms of what was too much benefits, we know that in 1954, the legislature decided that 104 weeks is too much for any employer to take on. So when I see a number like 208, going from 11.7 to 208, 37.4 to 208, I shudder to think, you know, where we go from there. So, you know, and this idea that, you know, 31308A at its core is a discretionary benefit. We're supposed to go to a 308A hearing and make the argument that maybe they're not entitled to such benefits. Now, those of us who have been practicing as long as we've been practicing know that that's a riot, because of course you're going to get those benefits, because it's not a discretionary benefit as long as it's on the books. You're going to get something, and in more times than not, you're going to get all that the statute allows. And this idea of full base rate, if you're doing job searches, you know, there's a twofold problem with that concept. The first is the 31308A benefit is supposed to have a relationship to the reduction in earning capacity, you know, and in a statutory framework where we measure, you know, what they were making before between what they're making now or what they're capable of making, you know, then practical realities, like we happen to live in a state that jumped in minimum wage from, you know, $10 or $11 to $15 in a relatively short period of time. So the idea that somebody's earning capacity didn't increase financially just by virtue of a statutory precept, and just ignore that and say we're going to pay them at the full base rate, is to ignore the fact that we're supposed to be measuring a loss of earning capacity. And I don't know that the idea that job searches is somehow determinative of the maintenance of benefits, when, you know, I mean, I don't go to a hearing, you know, I don't think there's been a week in the last 10 years where somebody hasn't said to me there's no statutory requirement, you know, to do a job search, you know, based on a misinterpretation of a arcane CRB decision that doesn't actually say that. But at the end of the day, you have to demonstrably perform a job search, and we spend, you know, probably 10 or 20% of our time fighting over whether something is a legitimate job search or not. And, you know, in my 29 years, I've seen exactly two people get a job as a result of doing a job search. So it's an exercise that we engage in, and I think to a large degree it's a fiction that we all maintain in the name of, well, at least we have some ability to make them do something in furtherance of their entitled to benefits. But the idea that 31308A is at its core a discretionary benefit that should be measured by the loss of earning capacity caused by the permanent partial impairment, a 5% to the finger, it causes a negligible loss of earning capacity, depending on what they do. I mean, they could be a piano player, I get it. But in general, a 5% loss to the finger, now you're saying that they're entitled to 208 weeks of benefit. That's a full base rate as long as they're doing job searches. I mean, the practical application of that is too much. But, you know, I mean, I have a lot to say about the individual body parts. The skin in particular, I mean, you're adding the skin to the statute from 0 weeks to 208 weeks, but your parenthetical actually belies that there is no deficiency in the availability of benefits because there is, in fact, a scarring award. The scarring, to the extent that there is a disability there, the scarring and disfigurement award can take care of that, and you can tweak 31308C to accommodate that without adding more body parts to 308B. Again, I just, and the cervical spine, I don't understand. I mean, the cervical spine was 175 weeks before, and it went to 117 in 1993. So I don't know how we plummet. I don't know how we rocket all the way back to 374. But I don't know. I get the sense that maybe this was a intentional expansion of what you actually wanted, expecting that we were going to say exactly what we're saying, which is this is too much.
Okay. All right, thank
I'll
you.
stop now.
Oh, no, you can continue if you want to. All right, go
No,
ahead.
it's not. I'm
Am I up?
Yes, go ahead.
So again, keep in mind, this is a situation where the employer has not been able to accommodate the restrictions caused by the work injury. We do have 31313, and I don't think I've ever seen that enforced in my entire practice. 31313 requires employers to provide light duty if it's available prior to MMI, I believe. Do we then somehow extend 31313 past MMI to require employers to accommodate these restrictions to get people back to work and somehow make 31313 more enforceable? Obviously, there are now more federal and state laws on the employment end, most of which I'm unfamiliar with, quite admittedly, but I just throw that out there too.
All right, thank you. Anyone else? All right, go ahead, Tim.
Thank you. Just, Bud, can you, I'm on the statute now, and you said 31313? I'm in the statute now, and
If I'm remembering that correctly.
it skips from 308 to 309 to 368 or something, 349. I'm just trying to follow along on that since this is not in my wheelhouse. So, and I've had two cases, just to follow up on your comment. I've had two cases where I had two people injured and couldn't climb ladders, so I provided light duty for them. It's kind of tough in the construction world, but I was able to do that. So to mitigate them, having to stay on disability. But
yeah, I've had cases where employers have accommodated restrictions. What I haven't seen is when there is light duty available and they're not offering it to the injured worker, and then I go to a hearing on it. I've never seen it enforced. But 313 is transfer to suitable work during a period of treatment or rehabilitation because of physical incapacity. It's my understanding, read the statute in a while, but my understanding is prior to maximum medical improvement, the employers were required to provide light duty if it's available. And of course, they always say it's not available. So.
Or you have the state of Connecticut limits it to, I think their light duty is up to 6 months, and after that, if you aren't back to regular work, they they stop their light duty work.
Yeah, I mean, there's various tricks, obviously, if they're working, second shift because their spouse works another shift and they have children, then, if they're injured working third shift, they offer them a first shift job or something, that they can't possibly take, so. Does that answer your question, Representative Ackman?
Thank you. I'm just going to keep looking for that in the statute. So thank you. Appreciate it. Appreciate that input though.
Rep. Ackert, I'll send it over to you so you have it.
Thank you.
Brooke, getting back to your point on increase in premiums. And perhaps this is not a fair question, and maybe it isn't even done this way, but when an insurance company decides what it's going to charge for a premium on a workers' compensation case, obviously they're looking at the difficulty of the job, the likelihood that somebody's going to get injured. In my law office, carpal tunnel or a raging infection from a paper cut is probably going to be the most likely thing that is ever going to happen, as opposed to a manufacturing job where certainly there are other risks. But when they're coming up with the premium, do they allocate certain amounts of money in the basis of the premium for covering things like PPD benefits or post-specific 308A benefits? And I guess simplifying it even further, I mean, let's say that the cost of the policy was $1,000 and 100 of it was what they felt that permanency ratings could eat up as part of it. I mean, is that how these things are calculated, or is it more complex or simpler than what I'm thinking?
I think there's a lot of factors that go into it, but it's based on risk, based on the job the person does, and a lot of different factors. And unfortunately, I don't have all those specifics.
Okay.
But I know it does depend on the job, and it can get very expensive, especially if you have high risk jobs like roofers, and that employers can end up paying a very significant portion of the hourly rate for each employee for their insurance just to cover them. So
right, but I mean,
I can't comment exactly on all of the different factors that they take into consideration, but it is based on risk.
Okay.
Yeah, I used to do that work quite a few years ago, and it was we would ask to figure out how to do it. You'd ask for the job description. Sometimes even folks would come out and see the work if it wasn't usual customary work. Like a roofer, we kind of all know what they do during the day, but they would come out and look at it, and they'd use the codes, the federal codes for jobs, and it all went into statistics and computer systems as to likelihood of risk and likelihood of injuries. And a big issue was if folks were miscalculated. So if you could reduce your rates heavily, if you had people out in the yard considered office workers, it's how many numbers you had of which category, because each category, as you know, has different risks. Our risk, very low, paper cut. Probably, I would say driving back and forth to the comp office and motor vehicle collisions are most likely risk, but hopefully not our fault, and hopefully we're all safe. But again, if you're working with fast, heavy machinery, high risk. If you're sitting at a desk, very much low risk.
Okay. But I mean, I think, the point I'm trying to get at is let's just say that you double the amount of weeks that you could collect on 308A benefits. That doesn't mean that the insurance policy is going to double in cost. I mean, it's just a component of what goes in there. And while I certainly, agree that the more benefits that are available, that's going to translate into an increase in premiums. But, I mean, I don't think it's quite that formulary, is it? So, all right. Well, I just throw that out there. Now, are there any body parts that we don't think we've addressed in this proposal? I mean, maybe some that, you know, the amount of weeks is probably too high and maybe it should be lowered, or other things that should be discussed. Marie?
Well, it's really just a question on my part looking at this, because number 4 says catch all for unlisted body parts. So will that take us out of having an actual schedule that people can rely upon, because they can now claim permanency and they're after 308A for any body part? Is it going to be just maybe an expansion of the scheduled body parts, or really it's anything goes?
Yeah, go ahead, Bud.
Yeah, we were trying to come up with all the body parts that aren't listed, you know, like the intestines, for example. And just figured that you're just not gonna be able to do that, right? You're gonna leave some out. And so rather than do that, return to what there used to be a catch-all in 308B for the unscheduled body. Of course, back then, all the body parts were unscheduled except for a handful. But the catch-all was just to address the unscheduled body parts.
Okay.
So the answer, I guess, is yes. Any body part will be under this proposal. And I'm not commenting either way on whether I agree or disagree with it. I just want us to be clear. Under this proposal, basically any body part will be amenable to a rating.
Correct.
If there's a permanent condition, yeah.
Yeah.
Yeah. And we even drafted language for that. So. I think and I just want to say this in reference to what Joe was saying about the you give someone discretion, they're always going to go to the max on it. There are ways to put limits on that. I'm more than happy to discuss that. Or so that's something I see that can be easily ascertained in terms of putting a limitation on that. And I think what Bud and I were trying to do is, as I said, is engage the discussion and see where, at least, you know, take the pulse of the group and see where we fall on it. People think there shouldn't be ratings for the skin, or, you know, you don't want to increase the ratings of the neck to 374 or the 208 and 194. And fine, but certainly there's things in here that I was hoping that at least business was willing to discuss, and then we can come up with the ways to, you know, see what makes sense and where we fall out on that. And the second part is, as I said, is there's a number of mechanisms you can put in that put a check, if you will, on the discretion. So as soon as you walk into a hearing on 308A, you're not always looking at 208 weeks. And I will say this, there's plenty of people who get ratings that go back to there's a lot of them. I know with cases in my office, it's not every case where someone has 308A just because they got a rating. So, but, and I just wanted to put that out there. I'm more than happy to discuss that, and maybe the thing to do, if the chair thinks, is we form a subcommittee to talk about these things and see if we can come up with some sort of ideas or consensuses that may make sense or not, and open-minded to everything.
Go ahead, Colette. And you're on mute. Or if you can't find it, you can hold down the space bar and that'll allow you to talk.
There you
Okay, sorry, it doesn't always come right up. So just to reiterate, I think really both what Brooke and Joe commented on, I would feel a lot more comfortable having the base information before we jump ahead to this wish list, if you will, from the claimants, because I think we need to establish, what we're looking at and why we need to make the change, if at all. And in terms of discretion, while I appreciate, Nate, your comments, we all, I think, have experienced what discretion leads to, which is ongoing litigation of the issues, which I don't think serves any of the parties here necessarily well. So I think we need to keep those things in mind. And I'd like to start with, are there changes really needed and why that is? I don't think we've gotten to that. I think we've jumped ahead to there's a necessary issue and therefore we have to somehow resolve it. But let's start at the beginning.
Okay. Colette, let me ask you, have you ever heard in the last 29 years how the NEC rating is insufficient? Have you heard it from members of the respondent side, the claimant side, the judges? Have you heard that before?
Well, I mean, of course I've heard that our benefits in general are insufficient. And, the workers' compensation is meant to accomplish certain purposes. Are there cases in which perhaps we can never replace somebody's leg? But we need to look at it in the context of not have I ever heard whether the benefits are not sufficient for a particular case, but in general, what can be sustained. I mean, as Joe, I think so appropriately said, at the last meeting about, why did we have the changes in 1993? We want business to stay in Connecticut. It's good for everybody here. And we want it to be affordable. I recognize, Nate, we also want to have workers who can work and can function. But I don't know that increasing these certain benefits is what leads to that conclusion.
And I'm not certain that why should the injured worker bear the brunt of employers staying in Connecticut or not staying in Connecticut? And that's what is being suggested by what everyone saw as draconian cuts in benefits, in comp rates, in entitlements to the scarring, and dropping the specifics by a third. I mean, it was drastic, and you were back practicing then. You knew what was going on with it, and the way it was done in the cloak of night without any discussion, no public hearings on it. It was just horrendous what happened on that. So, okay, injured workers have bore the burden for 29 years of this. All they're saying is that, you know what, given that, and we're not looking for a wholesale change of saying we should go back to 2/3 of the gross or there should be unlimited 308A. We're just saying that when you look at the whole statutory scheme of things, there are inequities, and there has to be some that we can agree on that can be changed and modified for. So number one, at least for the person, let's just take the people that want to get into rehab. Clearly, someone with a 20% of the NEC who's not going to start rehab until close to the rating and if they're in a 1-year program, those benefits are going to expire before they're even completed with their program. Certainly, we could agree that there should be some discretion that the commissioner has to fashion a remedy to at least get that person through that program. I would think that we could at least agree on that. But to suggest that, well, we have to see all these facts and statistics. Okay, your people on your side have those facts and statistics. All I have is anecdotes, of the 20,000 cases I've handled over 35 years, I have anecdotes. Bud's got anecdotes. And representatives have heard stories in public hearings about these things. So if you want specific statistics, let's find them. We're not the people that can provide those because we don't have that. We have the stories, and we have there are cases out there that are some are reported at the CRB level, some at the trial level. But the bottom line is when we took the full scale of everything in the workers' comp, what Bud and I did was thinking, okay, these are what keep coming up. These are the situations and body parts that seem to bubble to the surface. So let's just put them on the table and see where we can go with it. And if there are modifications that don't need to be made and they can be justified, so be it. But if there are ones that can be, there's nothing wrong with giving a little fairness back to a person has destroyed their earning capacity because of an injury. After all, it is the Workers' Compensation Act for a reason, as I see it. So I'm willing to work, Bud's willing to work, and I'm sure Colette, Joe, and Brooke, we're all willing to work and find some common ground on something. That's what we think. And I think that's what the charge of this committee is to explore these different situations. And maybe perhaps we're overstating it. Maybe you're overstating it. But perhaps maybe there are things that can be engendered that would bring a sense of fairness. And I will say this about commissioner's discretion. There are ways to curb it without just putting caps on it. There are ways that we can consider. I don't want to go into that right now, but I would certainly more than happy to put those out if there's an interest in it. Because I think that if the issue of discretion is being brought up by Joe and yourself, Colette, and Brooke, okay, how do you curb that? What proposals would you suggest that might work? We're certainly willing to listen to them. I'm not the first person to think that, I've been hurt by commissioners' discretions too, and so have my clients. So it cuts both ways on it. So if you're looking for more information, I'm more than willing to find it, but all I can provide is the anecdotal. So.
All right, anyone else? Go ahead, Tim.
Thank you. So I'd like to jump to the language a little bit that was provided. So you have the list that were discussed 1 through 4, and then just a brief reason of the changes. Is that more in line with what practices the language change, starting with removal of or for disfigurement or scarring, and those type of things? Is that more to just clean it up and make it adhere to what we're adding for those areas, or what? I can see taking into account, removing the age and sex of the claimant, things like that. So just a brief reasoning for is that really like so instead of the administrative law judge in replacement of the commissioner, because that is actually who makes the award of such compensation, things like that?
Yeah, I mean, that was a simple language change because we had legislatively changed their title from commissioner to administrative law judge. So that's just cleaning that up. Yeah. Age and sex, I mean, obviously.
Right. That's simple.
We're in a different time.
Yeah. I think we were in a different time then too. That's fine.
I think we were, and it amazes me that it was in there in the first place. But in any event, so yeah, I mean, those were just making some more technical changes rather than anything that was actually going to cause financial harm.
Yep, I just wanted to check on that language and see if everybody's kind of good with that and in terms of, I see the weeks change bumps that out. Obviously that is an impact, but just the other language part, I was just trying to get clarification on that.
Thank you. Rep. Conley.
Thank you. Had a discussion. I know there's some disagreement, which I think is always anticipated in things when we have folks who represent workers and folks who represent businesses at the same group. So I appreciate that the disagreement has been cordial, as the workers' comp bar is and continues to be. And folks can disagree politely. And I appreciate people who see this can see that you have folks who represent injured workers and companies zealously disagreeing, very politely with each other. But I would like to say, I think the thing that I think a lot of folks are trying to remove with this is the realization that when you have the injured worker and again, these are injured workers with accepted claims. These are not disputed claims at this point because they have permanency. So these are accepted work injuries. And you have an injured worker who cannot return to full duty, so cannot work in their job and their trade. What do we do to assist that? What do we do as the government, which is talking about the bill, what does the government do to assist that person in getting to full duty work? Because if this, and that's I think why we had the presentation last week of voc rehab, because if we can't get folks into voc rehab who have permanent disabilities, who can't do their prior job, if we can't get folks to get new trained, to get back to skills, to get back to full duty work, we, the government, in a different arm, will pay for that. It may not be the employer, it may not be the insurance company. It's the person who needs healthcare, it's the person who needs food, it's the person who needs housing assistance. If folks aren't working, they still need their basic necessities. And I see a big barrier to voc rehab of wages. And I appreciate, and I'll continue to ponder the proposal, negotiation with others as to what's the appropriate amount of weeks. But getting folks into voc rehab, getting folks retrained to new professions is possibly one of the reasons why we see the job search is not working. Because if folks don't get new skills, if you've been a roofer for 30 years and you can't climb a ladder, what are you going to apply for? What are you going to do without the skill? And I think that's what the system in the workers' comp system is missing, is getting folks who are permanently injured into their new skills so they can continue to work and be productive, tax-paying individuals. So I'd like to see how we can help that problem, because I think we're just passing the cost from right now from the insurance industry when they're done with payments to other branches of government and other branches of social services and other ways of taxes that we're paying for in a different way. And I'd like to get folks into voc rehab and retrained for their new lifestyle post-injury.
All right. Thank you. Anyone else? Okay. Well, I think this has been a good discussion. I would encourage anyone who has a different thought on these proposals to present something, and something may be leave it alone, don't touch it. But I'd like to hear that as well. I think we can work on getting some comparative data as to how we rate versus our surrounding states. And I think it would be instructive if we see how surrounding states handle permanency ratings and what they ascribe to different parts of the body as compared to what we do, particularly in the areas that we're looking to make changes to. And I would also encourage the folks who are of a mindset of not making any changes to, if there's data that backs up their position on keeping things the same, that we certainly would welcome taking a look at that also. So I think that, again, we have a starting point. And I want to continue this discussion in 2 weeks. And obviously, any differing proposals. We want to see those and let's have a discussion on those as well. And if there's anything else that anyone would like to see discussed at the next meeting beyond the things that I've just mentioned, then please let us know, and we will make certain that that's included as part of our agenda for the next time. So if there's nothing else at this point, our next meeting will be December 12th at noon. And without any other questions or comments, I will look for a motion to adjourn.
So moved.
Representative Acker and second by Representative Conley. All in favor?
Aye.
Opposed? Motion carries, and we'll see you back here